judges. We don't have a Russian or a British judge currently. This year is the 80th anniversary of the ICJ after the failure of the League of Nations and the establishment of the United Nations. There are 5 female judges out of the 15 judges. This is a precedent because throughout the past 8 years, we only had 7 female judges. This has its value, which I will not going to address the gender and the importance of the presence of women about the interpretation of law. ICJ has its limitations in work. It's capable of interpreting the law. Theoretically, that may be useful for the future, but cannot enforce the law because it has no enforcement body. In the end, it is the Security Council. I say this to say that ICJ does not operate without the full interference of other UN agencies, that they all work synchronically, and I will make it clearer in some cases. Hence, this is a future interpretation that may have this very slow and cumulative change in the ICJ. I'm going to address some cases in the first part of my speech related to genocide. As you know, in July, we had the advisory opinion on climate change by the ICJ. That was requested by youth from Vanuatu Island in the Caribbean requesting climate justice. The advisory opinion linked the human rights to climate change and other things. Several states, including Palestine, tried to link military wars and weapons with climate change. However, in their advisory opinion, did not address this. However, there is one female judge who spoke about the impact of war without mentioning Palestine, and she was the American judge. Also, the ICJ was affected by other advisory opinions. That's what I was trying to say, that they don't operate alone. Their advisory opinion on climate was affected by the opinion of the International Tribunal for the Law of the Sea. And also there was another opinion by the American or the US Human Rights Court. So the ICJ is also affected by decisions of other courts, including the US, European, and African human rights tribunals. I hope we will one day have the Arab Tribunal for Human Rights. It said that there are obligations on the states regarding climate change without mentioning particular states, but it said that some states have more impact than others. Those that have emissions have a larger impact than other states, and we find that some judges wanted a more progressive or a clearer expression of expression. For example, the Somali judge was trying to say that Germany had more emissions, causing more climate change than a country like Burkina Faso. This shows that the ICJ must play a role in shedding the light, not only on obligations in general, but on pointing particularly on the states that cause the problems. Some, like the islands in Caribbean, may disappear because of the climate effect. There are cases that are precedents and have an impact on the decision of the case of South Africa against Israel and Nicaragua. There are many cases towards the end of 90 by the former Yugoslavia against 10 states of the NATO, 10 states of NATO members. There was an attempt to press charges against those states that they were part of the destruction caused by against the former Yugoslavia. The court rejected the 10 cases. They included Portugal, Spain, United States, 10 states, and NATO members. And the court faced a problem to prove responsibility or even the jurisdiction. They didn't even move to the content, but stopped at jurisdiction. The problem was that the United States had a reservation on the Article number 9 of the Genocide Convention, and this led to other problems. We also have Congo versus Rwanda, which was based on several human rights conventions, including the Genocide Convention. As for Congo versus Rwanda, Congo tried to say that Rwanda is accused of actions against human rights crimes, including genocide in Congo. The court at the time found that Rwanda had reservations on Article 9, the same article, and therefore it rejected this use by the Congo for the jurisdiction of the court. And also, Congo tried to use other conventions, and the ICJ rejected the jurisdiction. The decision was in 2006. We found that 5 out of 16 judges any state that has no judge can nominate another judge to represent it. So 5 judges issued a separate opinion saying that we cannot continue to use the reservation against the jurisdiction of ICJ on genocide because this contravenes with the purpose and the spirit of the Genocide Convention. The decision is uses the advisory opinion. So the ICJ continues to stick to judicial precedents since 1951. At the time, the ICJ said that the reservation of the jurisdiction does not cancel the convention, and this allowed, therefore, Rwanda and the United States, they all have reservations. And we'll go to the Sudan versus UAE, Emirates. There's a war inside Sudan, but Sudan accuses the United Arab Emirates that they're supporting the rapid response forces. The Sudan went to the court and claimed that UAE finances the rapid response forces and is complicit in genocide. Before the ICJ looked into it, said that UAE has reservations on Article 9, therefore the whole case is dismissed. Not only the precautionary the interim measures. The court, and because there are some judges, or the majority of judges are traditional and adhere to precedents, they dismiss the case. However, there were 7 judges, and this is the slight improvement, which gives us some hope. 7 out of 9 judges, and there are 16 because the judge Nawaf Salam was retired, and the 15th did not arrive, which is the Jordanian judge. So 7 out of 9 refused the ICJ decision and said that you cannot continue to stick with the judicial precedents. Not 7 out of 9, 7 versus 9, 7 out of 16. At the time, there was a probability. And they said if the 15th, if had he been present, then maybe we could have been a bit closer, so that the court will try to change its adherence to the precedents, to give some opportunity for Sudan to listen to their arguments. Of course, UAE was pleased with the decision, while Sudan considered it a setback. And now we see the situation. I will have a citation here from the Chinese judge on South Africa against Israel. She is a Chinese judge, and who tried to tell the court that you cannot continue to use those precedents, and that we made some improvement, but we need to continue. She said that since more than 60 years, when Ethiopia and Liberia press charges against South Africa because they touched on their obligation as mandates in Southwest Africa, the court refused their capacity because they had no legal interest in the cases. This was faced resentment by member states in the United Nations against the court, and it harmed its reputation. That happened 60 years ago. This legal problem developed with the Barcelona traction case, where the ICJ recognized that there are in the international law certain international obligations on the whole international community. Because of its importance, all country states have legal interest in protecting them, and these are called the erga omnes obligations. Nevertheless, the court did not address in its judgment the legal capacity. While the law and practice are continue to evolve, the protected groups such as the Palestinian people, regarding them, the international community has a joint interest to protect them. In her opinion, this is the kind of cases in which the court must recognize the legal capacity for a member state in the Genocide Convention to press charges on the basis of erga omnes partis, which is the Article 9, to hold another member state accountable for breaching its commitments in accordance with the Genocide Convention. So there was progress in the court in the case of Liberia versus until it went to the Barcelona traction. Of course, we can look at the Gambia versus Myanmar. In this case, this is similar to South Africa against Israel. Gambia is a small state that is not a party in what's happening in Myanmar against the Rohingya. And they decided to go to court to say that the government of Myanmar is committing acts that may be genocide against Rohingya. This is being seen at the court. We see that Gambia chose the judge to represent her as Pillay, who is a South African judge, not only who supports Palestine, but also she is the chair of the Independent Human Rights Committee in the Palestinian territories, and who issued a report in September in which she said that what's happening in Gaza is genocide. This is important. We're speaking about Gambia versus Myanmar, and the judge representing Gambia is Pillay, who says that there is genocide in Gaza. This means that if the judge decides that there is a responsibility from Myanmar, this may be a good precedent for South Africa versus Israel. This is why everybody is looking at this case. As for South Africa against Israel, as you know, there were the first three interim measures. However, Israel is procrastinating. It's asked for first extension to submit. It's the counter memorial. Africa submitted its full file, and Israel requested the first and the second extension, and of course depends on who chairs the court and the extensions. The most difficult part is the intention and to prove intention, because there are precedents in the Balkan War cases, Bosnia versus Serbia and Montenegro, and Croatia against Serbia and Montenegro, and in which the court said that the only reasonable conclusion to identify the intention for genocide, that the only conclusion is its intention to destroy the group fully or partially. And this is the difficulty with the case of South Africa versus Israel. The court to say that there is no other intention by Israel except to exterminate the Palestinian people, and Israel continues to say that we don't mean to exterminate, but we want to respond to an attack that occurred in October 2023, and we are in a war over sovereignty over this territory. And Israel always says this, and there is political and legal pressure on the court on how to interpret the genocidal intent to prove its responsibility. In the Balkan Wars, ICJ said that in Srebrenica, in the massacre that happened, there is genocide, but it was difficult for the court to say that Serbia is responsible for the genocide, and it faced difficulty to say that there are reparations for genocide. And this is part of the difficulties the court faces, and all states must cooperate in pushing the ICJ to have positive interpretation. The court is not separate from what happens in the independent commission of a human rights report has a positive impact on the opinion of the ICJ and the states and how they react with the states. All this has positive impact. There are national courts, as Gamza and Talia were saying. The decisions that happen in Belgium, also the ICJ will look at them because it doesn't work in isolation. The next case is Nicaragua versus Germany, and this is a very important case since we have the state of Nicaragua, which is a Latin American state that decided to hold to account Germany, which is a European state, for providing Israel with arms and for cutting the funding of the UNRWA. They spoke of two crucial points on how Germany contributes to genocide, and Nicaragua was based itself on the South Africa versus Israel, and said that there is reasonable reason for genocide and that you continue to look into this case. The main problem here is that Germany, of course, contests the jurisdiction, claiming that you are addressing the case with a third party that is not member, which is Israel. This also happened in East Timor. And Australia. And Australia used the same rationale with Indonesia, that there is no jurisdiction because the third party, at that time it was Indonesia, and now Germany is using the same rationale to say that Israel is not party in this case and that no decision should be taken. So the ICJ faces difficulty on how it can be go in against its previous precedents. And also it depends on the representatives of Nicaragua, for example, and how they can present supporting arguments to continue the case and that there is jurisdiction, on the hope that they will finally say that Germany is participating through providing weapons and cutting the funding of UNRWA. In the end, I was still speaking about the first part of my intervention. In general, the court adopts a conservative approach and strikes a balance between the law and the politics. The other speakers, like Dr. Ralph, spoke about advisory opinion of last year about the illegitimacy of the presence of Israel in OPT, including East Jerusalem, West Bank, and Gaza. This advisory opinion, which many people considered a very significant improvement, continues to have certain gaps which we can use and maybe we can reject. In the end, the ICJ decides that self-determination of Palestinians is within this framework, which is West Bank, Jerusalem, East Jerusalem, and Gaza. This is not only a problem, but it used the Security Council and General Assembly and the resolutions on interpreting the law. The difference here is, for example, in the case of Namibia or South Africa, or South African mandate on Namibia, there were many advisory opinions at the time. At that time, a very clear South Africa advisory opinion said that South Africa at the time is an illegal power and force in Namibia, and they must end their mandate and control immediately. And they used the word immediately. That happened in 1971. In Israel, ICJ said as soon as possible. This is a difference in language that has political consequences on the ground. In the 70s, there was power, there was the Soviet Union, there was an environment of ending colonialism in Africa, there was a Security Council resolution to end the mandate of South Africa over Namibia, there were very strong GA resolutions, there was a political atmosphere that enabled and encouraged the ICJ to speak about ending the South African mandate over Namibia. This is different from the case of Palestine now. And the last advisory opinion that was issued last October on the UNRWA, also some considered it very progressive, or at least it proved that Israeli claims that UNRWA is infiltrated by Hamas, as they claim, Court said that this is baseless. And all of them used the ICJ conclusions to demand to continue the support for UNRWA and to renew the mandate of UNRWA. Usually, the mandate is renewed every 3 years. The problem is that the ICJ said that UNRWA was established in 1949, but it jumps from 1950 to 1967, as if there is no mention between 1950 and 1967, and the court doesn't know how to deal with this period. And it said in 1967 there was an occupation for the West Bank, Gaza Strip, and East Jerusalem. There was an agreement with Israel. Accordingly, UNRWA must resume its operations. And also, it spoke about Israel obligations as an occupying force, as a UN member, and there were also some some problems. It spoke about cooperation between states and was interpreted in a very abstract form and without any binding form. And the ICJ was hoped to divert a bit from abstract obligations to say that the obligation to cooperate between states within the principles of the UN, that this must be mandatory and not voluntary and not up to the interpretation of each state separately. Israel interprets those obligations on its own, and they engage with the ICJ accordingly. Israel submitted a written opinion, unlike the other advisor opinion. The ICJ spoke about the Red Cross. That was positive, in my opinion. They said that the Red Cross must resume its visits to the Palestinian prisoners. Not many international organizations said so. In the end, the Judge Ladi from South Africa provided a separate opinion saying that in the 70s or even before, there was a Judge Lauterbach, who was Zionist, who spoke about South Africa and Namibia, and he said that since the state is not compliant with the UN principles, we need to say that this state has betrayed the principles of the United Nations. We can interpret this is a call to stop the membership of United States of Israel in the United Nations. In the end, I'd like to say that the law itself has no power and will bring nothing. It is a disclaimer. The law itself is a tool, and the court produces what happens in terms of political interactions outside the court. This is a call to see how in the 60s and 70s there was a different impact of the General Assembly or the ICJ itself with the causes of the peoples. And we can see that through states from the global south and how they deal with international law. Thank you, and I apologize for being lengthy.